Things the power to amend the Constitution cannot be in the residuary entry in a federal constitution, because the power to amend the Constitution will also include the power to alter the distribution of subjects mentioned in different entries. Such a power cannot obviously be a legislative power. Irrespective of the source of power, the words in Article 368, that the Constitution shall stand amended, indicate that the process of making amendment prescribed in Article 368 is a 11-elf executing process. The article shows that once the procedure prescribed in that article has been complied with, the end product is the amendment of the Constitution, Paper 646-648. The word law in RTI La 13.2 does not include an amendment of TB Constitution Aberaese 758. An amendment of the Constitution made in accordance with Article 368 does not constitute law for the purpose of Article 13.2. The word law, although referred to in a large number of other articles of the Constitution, finds no mention in Article 368. What follows as a result of the compliance with Article 368 is an amendment of the Constitution and not law in the OCNs of ordinary legislation. There is a clear distinction BTWCN statutory law made in exercise of legislative power and constitutional law made in cursus of and constituent power. The Constitution is a fundamental and basic law and provides the authority under which ordinary law is made. If it had been the intention of the framers of the Constitution that the law in Article 13 would also include constitutional law, including laws relating to the amendment of the Constitution, it is not explained as to why they did not expressly so state in Clause A of Article 13.23. The Constitution itself contains indications of the distinction between the Constitution and the laws framed under the Constitution. It is difficult to accede to the contention that even though the framers of the Constitution put no express limitation in Article 368 on the power to make amendment, they curtailed that power by implication under Article 13.2 in order to find the true scope of Article 13.2 and the context of 1ts possible impact on the power of amendment. It should not be read in isolation, but should be read along with Article 368. The rule of construction is to read the actual words used 11 not in vacuo, but as occurring in a single complex instrument, and which one part may throw light on another. A combined reading of Article 13.2 and Article 368 clearly points to the conclusion that the extinguishment or abridgment of fundamental rights contained in Part 3 of the Constitution is not beyond the secondary work conferred by Article 368. The alleged conflict between Articles T is apparent. Real because the two provisions operate different fields and deal with different CRCTT Article 368 is independent and self-ain't-a-one. If there any LTM 111 on the power of amendment, it must be found in Article 368 itself, which is the sole fountally HCAD of power to amend, and not in other provisions dealing with ordinary legislation, pp. 655 to 6SK. Tia United Patolians Viemen, Alika Begumon, 1940, 2 FCR 110, USV Commonwealth Australia, LNJ6I 578, RFEMD 2436 SC India, 350 Supreme Court Reports, 1973 sub PSC, LT Pooner of Amendment under unamended Article 368 does not use the power to abrogate the Constitution, nor does it include the Jiao alter the basic structure or framework of the Constitution subject to the retention of TID. Basic structure or framework of the Constitution. The power of amendment is plenileveny and includes within itself the power to amend the various articles of the Constitution, including those relating to fundamental rights as U1L as those which may be said to relate to essential features. No part of a fundamental right can claim immunity from amendatory process by being described as the essence or core of that right. The power of amendment would also include within itself the power to add, to alter, or repeal the various articles of P. 758, 759. There are no words in Article 368 to indicate that a limitation was intended on the power of making amendment of Part 3 with a view to take away or abridge fundamental rights. The words "the Constitution shall stand amended" plainly cover the various articles of the Constitution. It is difficult in the face of those clear and unambiguous words to exclude from their operation the articles relating to fundamental rights. It is an elemental rule of CI, instruction that while dealing with a constitution, every word is to be expounded in its plain, obvious, and common nonsense, unless the context furnishes some ground to control, qualify, or enlarge it, and there lie not be imposed upon the words any recondite meaning or any extraordinary gloss. It has not yet been erected into a legal maxim of constitutional construction, that words are meant to conceal thoughts. It cannot be said that the framers levief